All right, good morning again. This is Judge Krier. Madam Clerk, I just wanted to go over with you. I had a number of cancellations late yesterday. 19 CA 4268 canceled, 20 CA 3730 canceled, 20 CA 3529 canceled, and 21 CA 921 canceled. Is that accurate?
Yeah, pretty much.
Okay. All right, so the first one then I have remaining on my docket is 20 CA 3505. It's Perez versus Security First. Who's here for the plaintiff? Anybody? We're about a minute early. Anybody here for Rafael Garcia Perez? No? Okay, moving on to the next case. Kevin Parsons and Colleen Parsons versus St. John's Insurance, 20 CA 4000. Who's here for the plaintiff? Really? Plaintiff's attorneys are late. All right, moving on.
Not me, Judge.
Okay. Scavolino versus Vincent Corrado, 21 CP 1168. Who is here for the petitioner, the original petitioner? Is that Mr. Kuhn?
Yes, Your Honor. Scott Kuhn on behalf of Julia Scavolino.
All right, and then who's here on behalf of the person who filed the objection? I think that was Deborah Stewart. Is Miss Stewart here? It's now 8:30. Everybody should be here.
It was Miss Stewart, Your Honor.
Is she withdrawn or something that I don't know about?
I do not know. I have no
Well,
contact.
I'm going to go back to the top of the docket and see if anybody's showed up in the other cases. But here's the thing, Mr. Kuhn, I'm going to tell you, which is, as you probably know, the will has a different distribution than the one that you suggested in your petition.
Correct. That's correct. But he agreed and signed the waiver.
Well, but apparently he's withdrawn that waiver. So,
well, I don't think he legally can. He hasn't met the test, respectfully, Your Honor. I mean, he signed a waiver.
all right. Well, I think I'm not signing an order on a summary petition for summary administration when it clearly is contraindicated in the will. So,
I understand. We'll amend the petition.
We'll come back and see what Ms. Stewart has to say, but nevertheless, it was suspicious to me. All right, now, let me go back to the top of the docket. 20 CA 3505, Perez versus Security First. Who's here for the plaintiff? Really? Okay, anybody here for defendant? Maybe they canceled, forgot to tell us. All right, Parsons versus St. John's Insurance, 20 CA 4000. Who's here for the plaintiff?
I am, Your Honor, Gabriela Ibanez Ehlers.
All right, who's here for the defendant?
And Emilio Dominguez on behalf of St. John's, Your Honor.
All right, this is plaintiff's motion to compel deposition of desk adjuster. Go ahead.
That's correct. Your Honor, we've been requesting the desk adjuster deposition for quite a while now. All of our requests were essentially non-responded to. We did receive one response to our second request, essentially saying that they would revisit the issue of the desk adjuster later on in the case. When I requested that they
stop. Mr. Dominguez, what's the scoop here?
Yeah, Judge.
Unfortunately, you don't get to conduct how this goes. They want to take the deposition of the desk adjuster, they get to take it. Give them a date.
I understand, Judge. The issue with this case is that, and I only got involved in the case last week, so I'm sorry, Gabriela, if we went unanswered. But anyways, the issue with this case, Your Honor, is that there was no desk adjuster. There was just a field adjuster. We have one person sending out a claim acknowledgement letter, one employee, another one sending out a coverage determination letter, another one sending out a denial of the supplemental claim, but there's not one particular desk adjuster in the case, Your Honor, and that's the issue.
Well, but then the response should be, there's 5 different people that did these different things. Who do you want to take the deposition of?
I understand, Judge. And again, I only got involved last week, so I haven't had an opportunity to discuss with plaintiff's counsel. But we do have the corporate rep depot coming up at the end of this week, and there isn't any information that they shouldn't be able to get from that deposition.
But that doesn't matter. They get, this is discovery. You get to ask the same question 20 different ways of 20 different people. That's what discovery's like. That's what discovery's about. Okay, Ms. Ehlers, I'm going to grant your motion, but it does appear that you may be taking more depositions than just one.
Gotcha.
So you guys need to figure that out. I'm not going to award fees, but if the obstruction continues, I will reconsider that.
Okay, thank you, Your Honor.
So I'll need an order from you, Ms. Ehlers, sent to my office email address in Word format after you've circulated it to Mr. Dominguez.
Gabriella, can we agree to 60 days? 60 days to take depositions?
Yes, that's fine.
Okay,
Perfect. Thank you.
thank you. All right, next case is Jeske versus Florida Peninsular Insurance, 21 CA 144. Who's here for the plaintiff?
Paul Kuntz, Your Honor, for the plaintiffs.
All right, and how about defendant?
Daniel Tamaroff for the defendant, Your Honor.
Okay, so this is defendant's amended motion to dismiss or strike the complaint based on
Your Honor, before
some bad faith.
Okay.
Go ahead.
My understanding is the parties reached an agreement on this motion and we'll be submitting a proposed agreed order. We just reached it last night. So.
Oh, that's all right. Mr. Kuntz, is that correct?
That's correct, Your Honor. We just couldn't get it canceled in time, so we wanted to make sure you do.
All right, so just send me an order to my office email address in Word format, please.
Thank you, Your Honor.
Thank you, gentlemen.
Thanks. Have a nice day.
You too. All right, going back before I get to a couple longer hearings, anybody here for Perez versus Security First, 20 CA 3505? Plaintiff or defendant? Huh, well, there's a lot of people here for only a few cases left. How about Scavolino versus Vincent? Oh, well, we already did that one. Did Miss Stewart show up?
Yes, Your Honor, I saw her on there earlier.
Okay. All right, so this is 21 CP 1168. Mr. Kuhn's here for the petitioner. Ms. Stewart's here representing one of the beneficiaries. Like I
Yes,
can't
Your
hear.
Honor.
I can't hear you, Ms. Stewart.
I'm sorry, Your Honor.
That's all right.
I'm here.
Okay, well, I think I understand that the petition for summary administration does not request the distribution that's set forth in the will. Mr. Kuhn, however, raised a important issue, which is your client signed the waiver and the agreement, but now wants to rescind that. I'm going to have an evidentiary hearing to determine whether that he can do that, but again, I'm a little bit concerned about granting summary administration. I would have looked cross-eyed at this to begin with, without the objection. So,
Okay.
but you're going to have to schedule an evidentiary hearing on this for me to make a ruling, and I'm going to need to have some case law because, needless to say, this doesn't happen very often.
All right. That's fine, Your Honor.
Okay.
Thank you, Your Honor.
All right. Thank you, counsel.
Okay, we'll do that. So this will then just be
This is going to be
continued. Okay, fine.
And you need to contact my judicial assistant via email to schedule a time. Just so
Okay.
everybody knows, the courthouse is opening up on the 21st for in-person proceedings. However, the Supreme Court is encouraging us to do as many proceedings as possible via Zoom. I'm going to have specific days for Zoom hearings and specific days for in-person proceedings. If you want to schedule an in-person proceeding, you have to contact my JA via her email address, which is on our website. But other than is set forth, everything continues on Zoom unless you want to reschedule for an in-person proceeding.
Okay, is that June 21st they're opening up or July
Yep,
21st, Your Honor?
June 21st.
June, okay.
Yep.
Thank you, Your Honor.
All right,
All
thank
right.
you.
Thank you, Your Honor.
All right, next case is Frankowak versus Saab 21 CA 242. Who's here for the plaintiff?
Your Honor, Douglas Gould, G-O-U-L-D. I'm here on behalf of the plaintiff.
All right, and who's here for defendant?
Brantley Oakey on behalf of the defendant, Your Honor.
All right, well, this is a motion to dismiss for lack of personal jurisdiction.
That's correct, Your Honor.
Go ahead.
All right, Your Honor. As the,
And
Just
you
as a
ha- and
brief-
you ha- and you have filed an affidavit, so.
right, as a brief background, I guess, general claims of this case is that one brother, the defendant, traveled to Florida and met with the other brother who lent him money. There were two promissory notes, one promissory note at that first meeting, and then there was later a secondary promissory note that was signed by the defendant. So that's what we're discussing, is a breach of promissory note between
I'm aware.
two brothers. As you're aware, in evaluating a motion to dismiss for lack of personal jurisdiction, it's a two-part analysis. The first is whether or not sufficient facts have been alleged to bring the case within the ambit of the long-arm statute. In this case, that's been accomplished. They've alleged that a breach of contract occurred within the state of Florida. So the second question, and the more rigorous question, is whether or not there are sufficient minimum contacts for the court to exercise jurisdiction over the defendant. In this case, the defendant does not believe that that's been met. There has to be sufficient contacts for the court to say that the defendant has purposefully availed himself of the privilege of conducting business in the court, or the ability, the protection of the laws of the state of Florida before the court would exercise jurisdiction. It has to be such that the exercise of jurisdiction would not offend the traditional notions of fair play and substantial justice. It should be noted as well that contract in and of itself, the Supreme Court has ruled, does not constitute sufficient minimum contacts. Neither does the failure to pay money that is due in Florida. Instead, the court has to analyze the prior negotiations and the contemplated future consequences, along with the terms of the contract, to determine whether or not the defendant purposefully established minimum contacts or availed himself of the protections of the state of Florida. What I think is really important in this case for the court to note is that both of these promissory notes indicate that Massachusetts law is supposed to govern in all respects any dispute over the promissory notes. And so for that reason, I don't believe it can fairly be said that the defendant availed himself of the privilege of conducting business in Florida or the laws and protections of the state of Florida. The parties explicitly noted that Massachusetts laws should apply, and the protections of Massachusetts law is what will prevail. So what you have is one trip to Florida, signature of one of two promissory notes in Florida, and promise to pay in Florida as the totality of the contacts alleged by the plaintiff. But I believe that that is insufficient, especially in light of the fact that the contracts themselves require that Massachusetts law is going to govern these transactions. So for those reasons, we'd ask the court to find that there is not sufficient minimum contacts and then dismiss the case.
All right, Mr. Gould.
Your Honor, as an initial matter, the motion to dismiss for lack of personal jurisdiction doesn't address the second prong of the test at all. My understanding of the motion to dismiss basically is that the plaintiff does not allege the court has personal jurisdiction over the defendant, nor does the plaintiff invoke any portion of the long-arm statute in her complaint she could rely upon to exercise jurisdiction over the defendant. Our complaint clearly under 48-193 alleges facts that the Supreme Court has found before establish long-arm jurisdiction on the first prong of the test initially. And before I move on in the argument, I just want to say that the case law that I provided to the court and to opposing counsel indicates that once the jurisdictional basis under 48-193 is established, and this is under the Hilltopper Holding Corporation case. Mm-hmm. Once that's established, it becomes the burden of the defendant to come forward with information challenging those jurisdictional facts under that specific rung of the long-arm statute. The motion to dismiss here and the affidavit that was filed do not in any way contest those facts, that are relevant under 48-193. So the way the record stands, we've alleged the facts. We didn't allege the statute, but under the case law, we don't have to. We alleged the facts very carefully in our complaint to support the allegations under 48-193 1A7, which states breaching a contract in this state by failing to perform acts required by the contract to be performed in this state. And in the Morrow aircraft leasing case, where a payment is to be made under a contract in this state, that is sufficient under 48-193 1A7 to establish the applicability of that jurisdictional component. And Morrow cites two other cases for that proposition. So I believe under our case law, once we have established that, the burden then shifts to the defendant to disprove those facts, and that hasn't happened here. Specifically, the affidavit says that the defendant doesn't live in Florida. Well, we agree that he doesn't, but that doesn't do anything with regard to our allegation under the contract being formed in Florida and the payments being due in Florida. Number two, I do not do business in Florida. Well, again, we don't contest that fact as pled in the affidavit. We allege that he solicited a loan while present in Florida, signed a promissory note in Florida, promising to pay a Florida resident for the loan originating in Florida, and promised to send payments to the decedent's residence in Naples, Florida. We alleged he breached those terms and conditions by not making the required payments in Florida. So his allegation that he doesn't do business in Florida doesn't challenge any of that. He also says that he doesn't own Florida property. Again, we concede that he doesn't, but we're not looking for in rem jurisdiction under the long arm statute. So that component of the affidavit doesn't address our factual allegations. The contracts attached to the complaint are not Florida contracts and indicate they should be governed by Massachusetts law. Well, the first part of that is a legal conclusion, which the cases that I supplied to the court show that a legal conclusion doesn't contest the facts. It's just a legal conclusion. And the second part alleges a choice of law provision, which simply doesn't undercut our jurisdiction under 48-193. There's no argument that because there's a choice of law provision that there's no jurisdiction. And quite frankly, Judge, the fact that Massachusetts law may control, I can't imagine how much different Massachusetts law on the breach of a promissory note is than Florida law. But I know that we are all capable of addressing that issue.
Well, also, it's not a choice of forum, it's just a choice of law.
Correct, Your Honor.
Mm-hmm.
So in this instance, we also in the complaint went out of our way to set forth that this particular defendant, having made this promissory note, then took action to get himself appointed as the personal representative
in Florida
of the decedent, who was the person who granted him this loan while in Florida. And those acts, by getting himself appointed as the PR, effectively foreclosed the estate for over a year from being able to bring this litigation under the promissory notes. So he has plenty of contacts with Florida. And most importantly, Your Honor, he was present in Florida when he executed and created this contract, accepted the benefits of this contract. And so even if the court is to consider the second arm with regard to the issue of fairness of subjecting him to the jurisdiction of Florida, I believe our complaint amply sets forth facts that supports that.
All right, response.
Well, the fact that he served as personal representative is irrelevant to the question today because he's not being sued for anything that was done while he was serving as that capacity as a personal representative. It's relating to a separate issue, and so the contacts with the state of Florida are only relevant if they directly relate to the transaction that's being sued upon. As for the facts to bring it within the ambit of the long arm statute, I already stated that we do not contest that. We don't need to contest those facts. We're suggesting that they're insufficient. And the fact that the choice of law, you're right. It's a choice of law. It's not choice of forum, but it's still very relevant and important to the court's analysis because remember the question is, should Mr. Saab, the defendant, reasonably be expected to be hailed into court in Florida? That's one of the questions the court's asking in its analysis, and my position is no, because both parties agreed that Massachusetts law was to prevail. So the defendant would expect to be brought into court in Massachusetts. He did not, and then it's also relevant to the question of did he purposely avail himself of the laws and protections of the state of Florida, and the answer is no, he did not. And so I think because the answer is no to both of those questions, that just the fact that he came to Florida once, signed an agreement, and payment was due is insufficient to exercise personal jurisdiction.
Well, I disagree. I think it's completely sufficient and overwhelmingly sufficient. So the motion to dismiss is denied. You have 20 days to answer. Mr. Gold, I'd like an order from you after you've circulated it, sent to my office email address in Word format, please.
Yes, Your Honor, certainly.
All right, thank you.
Thank you.
All right, next case is Eduardo Alfaro Martinez versus various defendants, 16 CA 97. Let me just pull up the case, hold on. A bunch of things open in my desktop. Okay, here we go. All right, so the defendants that I have, first of all, who's here for the plaintiff?
Mark Weinstein, Your Honor.
All right, who's here for Naples Community Hospital? Anybody?
Well, NCH is not in the case.
Who's still in the case?
Well, I don't know what caption you have. They're not in the newer caption. When I say newer, it's 2 years old. Jessica Husty.
Okay, who's here from Husty?
Where is he? He's the main.
Okay, so in the amended complaint that was filed on December 21st, 2017, I still have Naples Community Hospital, Jessica Husty, Dylan Caldwell, Team Health, Southwest Florida Emergency Management. So go ahead.
Yes, there was an order granting at some point along the way to amend the caption.
Okay.
For instance, they settled the case with respect to the spouse. So I assume that this is not an issue I expected to come up.
Okay, let's just stop. Mr. Gantz, who are you here representing?
Good morning, Your Honor. I represent Dr. Dylan Caldwell.
Okay. Anybody else here for this case? Mr. Knapp?
Yes, good morning, Your Honor. Scott Knapp on behalf of Team Health, Inc.
Okay, and anybody else?
It would be important that Mr. Diaz be here. He represents very important defendants here in Jessica Husty and Southwest. It's all Team Health.
Who is Dan Meek and Ryan Marks?
I don't know that.
Mr. Meek, what are you here for? Well, I'm taking you off my desktop if you're not here for anybody.
Your Honor, Ryan Marks.
Yeah, who are you here for?
Thornton versus Krier.
Thornton versus, I don't have that on my docket for this morning. They must have canceled.
Oh, it was their motion for entry of and to enforce the settlement.
Just have to grant it.
Yeah, I don't have that on my docket anymore. I'm not even sure I ever had it on my
I'm
docket.
not doing them a favor.
All right, let me, I'll find out what the issue is.
Okay, thank you. All right,
Thank you.
so going back to Martinez, this is plaintiff's motion to compel. So go ahead, Mr. Weinstein.
All right, Your Honor. This is a half-an-hour hearing due to the sheer multitude of discovery outstanding. I guess I'll start at the beginning, as the song goes. Did you have the motion in front of you, Judge? And I just asked that administratively. Great. Okay. And because I'm a little concerned that the first issue, the one in Exhibit A,
Well, just to be clear, it's the motion that was filed on May 21st.
No, April 26th.
Okay.
This is plaintiff's omnibus motion to compel defendants' responses to discovery and overrule objections. It's the amended one because I added another one that they didn't respond to like a day after
they
filed it. Okay, do you have that in front of you, Your Honor?
I've got it.
Great. Okay. So Exhibit A. At Exhibit A, our defendant Husty's and Southwest responses. We don't have a lawyer for them here. Although the responses were served, they say to be provided, to be provided, to be provided, and there are additional objections made. I specify exactly which one. I'm prepared to go through them all, although there's no lawyer for the defendant here. So,
well, then that's their problem, isn't it?
yes. So for the record, I've a court reporter here. Exhibit A, I move to compel responses to requests 1, 2, 4, 6, 9, 12, 18, and 20, and to overrule objections made to 11, 17, 18, 19, 20, 21, and 24 through 33. I was concerned that it would be that one that would take up most of our time today, as you can probably hear.
Okay. And just for the record, the notice that was filed on May 21st, 2021 does specifically list Mr. Diaz as having received a copy of that notice. So
No, and not only that, Your Honor, I'll represent as an officer of the court that on that same day I received we received an email from Caridad, his scheduling secretary, confirming it and saying that he is available and I can notice it for that date.
okay. All right. So so granted.
Okay. Next, paragraph 3. All right. Yeah, I was about to say this is important. They're all important. This is really important. There's a press release released by Team Health and represented by Mr. Knapp, which I attach to Exhibit B. And what they do is they're touting how much more money they made because of all these changes that they made to the emergency department with respect to the manner in which patients are seen. It's called acuity level, without getting too much into the facts of the case. I served a request and asking them questions at Exhibit B about where the information come from, identify who authored this. I mean, you see it, I annexed it. I want to know who authored it. And I want all documents about what those countermeasures are that it refers to by general topic.
And their objection is relevance.
Basically, well, it's interesting. It's relevant, but I don't even know, couldn't possibly be more relevant. But they also say, well, it's too hard to look for. Plus, we got it in 2010. So I wrote here, well, how do they know that it was from 2010 if it's too hard to look for? But they also wrote that, well, something from 2010 couldn't be related to, couldn't be relevant. This is a 2014 occurrence, 3.5 years later. And besides, if they made the changes and they were still using the changes, they made the changes. I needed to pose these guys. I've been going after folks in charge of this.
So what are you
for a long
asking
time.
for with regard to your motion in connection with this?
I'm sorry?
What are you asking me to rule on?
Grant it. Overrule the objection.
Okay, so overrule the objection with regard to the request to produce in the interrogatories?
Yes, at Exhibit B.
Okay.
It's just, it's not even an interrogatory. It's well, the next one's the interrogatory, which is Exhibit C.
Mhm.
Okay, which is the same thing.
Okay, go ahead. And how many other issues do you have? You want to do these one at a time?
Okay.
All right, so go ahead, Mr. Knapp. What's your response?
Thank you, Your Honor. This is not something new. The concept of I need to depose these guys or I have no information. There's been multiple witnesses who have talked about these in depositions, including, for example, Dr. Bethel, John Stair. There's been question after question of corporate rep and witness on these areas. We have identified that the information that was gathered comparing this was from the years 2008 and 2009. We believe that it was published somewhere around 2010. However, it's so long ago that to try to go through electronic discovery of countless and who knows what type of custodians would be involved from this from an electronic discovery standpoint, it simply doesn't match the facts of this case. It is overly broad and irrelevant, as was stated. This case has nothing to do
Well, it may be relevant if these procedures were in place at the time of the alleged accident, but the question is, what are those procedures?
And it's not, and that's been talked about, is this is not procedure. It's not some written procedure. This is simply what was done to look at, verbalize. We've given them even Dr. Lewis's name. If you look at the interrogatories back in February of 2019, we said Dr. Lewis was the assistant medical director who was involved in the implementation of these things. But some of them, for example, consider shortening the triage process. There's no allegations about the triage process, about it taking too long. There's nothing about a lot of the different things that's overly broad, and those sort of things would certainly be irrelevant. The concept as well of somehow this is Team Health Inc. that's doing all of these measures and taking them into effect has been time and time again rejected by testimony and evidence that this was done by Southwest Florida Emergency Management through its staff, who's the exclusive medical provider and has a contract to be the exclusive medical provider at NCH. We're not disputing that Southwest Florida Emergency Management is an affiliate of the Team Health organization, but there's a large analytical gap between saying Team Health and saying Team Health Inc. They're very different. We've gone through this multiple times in this case. There's been a lot of depositions about this, and to simply say, give everything with regard to how this was done in 2008 and 2009 is an incredibly large task with no ESI protocol, no measures of how do you gather this information, and just simply sitting here saying, I'm entitled to this, somehow it's relevant. You have to eventually—
Well, hold on. Mr. Weinstein, if these procedures were not in place at the time of the alleged accident, why are they relevant?
They were in place. And I thought lightning was going to come through the window and strike Mr.
Okay, enough with the drama. Enough with the drama.
I'm sorry.
Yeah.
But what the witnesses he's identified have testified to is, I don't know what this is. I don't know what 9 countermeasures they're referring to. Here's the procedures that we did or didn't have in place. Now, I believe that those procedures, frankly, you tell me the punitive damages, they're so bad. I want to know it, and I'm sure of it, if this, and you have it in front of you, this is what they changed to, and I'm sure it is. They have not testified about this. All this testimony he's talking about, yeah, I asked the questions, and they said, I don't know who wrote it. I don't know what this refers to. And by the way, this isn't an old press release. It's on their website now. I don't want it disappearing, by the way, Mr. Knapp. Right now, it's on their website. I checked yesterday.
Okay.
All right, well,
Your Honor, there's a difference between when a press release was there and if it's accessible on the internet.
Okay, well, Mr. Knapp, here's the thing. The safety measures, et cetera, are relevant. The question is, how difficult or easy is it going to be to get this information? I don't really know the answer to that question because you haven't really given me any evidence about that. So, you know, I mean, you know, if you want to tell me, I mean, you've told me how difficult it's going to be, but I don't have any testimony or evidence about it's going to take us 3 million man hours to do this or whatever. I mean, I can't believe that something that's on a website that's for public consumption, that you could represent something that you don't have some backup for. So you have to have some backup. So I'm going to overrule the objection, but you know, I'll reserve ruling with regard to, I mean, again, I want it in the order, Mr. Weinstein. Again, I can't believe that something that's on the website does not have some documentary backup. So Mr. Weinstein's entitled to the backup. Now, I don't know how difficult that's going to be for you because you haven't presented any evidence to that effect, but I will reserve if I have to, you know, if we have to narrow this in some way to get the information. But again, you should have that. Somebody should have it in a file, whether that file is on computers or not, I don't know. But when you make a statement like that to the public, you should have this on file. So, all right, that's my ruling on that. So let's move on, Mr. Weinstein.
All right, thank you, Your Honor. It's the same thing with respect to what's at Exhibit C, which are interrogatories.
What page of your 134-page motion is Exhibit C? Because
Okay,
you have lots of exhibits mixed in with other exhibits, and it's very difficult to.
No, I think it's a 3 or 4 page motion, Your Honor.
Oh, then which one?
Paragraph, okay. Yeah, paragraph 3. I'm sorry. This would be paragraph 4 now, which is Exhibit C. But it's paragraph 4, and that Exhibit C are the interrogatories asking the same thing. Who wrote the press release? I mean, that can't be overly burdensome, by the way.
Okay, again, Mr. Weinstein, I'm looking at your April 26th motion, which is 134 pages. So with attachments, I understand which paragraph, it's only a few pages, the motion, but when you tell me to go look at an exhibit, I want to look at the exhibit. What page is it on?
Okay. Oh, the page of the PDF, you mean? Oh, that would be helpful. I see. Let me I'll pull that up. In the meantime, oh, gee. I'm used to, I was just referring to Exhibit D. I don't know what page it is of the PDF, but I can pull it up.
Because, and not only that, but you've got lots of Exhibit A's and B's in the attachments. So, because they're probably exhibits to your exhibits. So it's
only once. I think we only did that once. I'm sorry. 32. I have an assistant here with me who's pulling it up.
Excellent.
It's 32, I'm told.
Got it. All right. Go ahead. So, same issue you're saying with regard to Mr. Weinstein. You want to?
Yes. Oh, yes. You're on. For the record, it's just exact. This is just the interrogatories on the exact same issue. They were served simultaneously with the request for production that asked for the materials showing who the author was.
Okay. Well, I've already ruled on this, so we can move on from that.
Thank you. All right, and now I can give you PDF pages, Judge.
Okay. Your Honor,
I have a PDF here.
They're not simply a rehash of what's been done. I'll give some examples. For example, interrogatory number 6 is to identify the person or person with most knowledge as to the substance of information contained in the section challenges on said document. There's a plethora of Florida law, including the Carriage Hills case, which is probably cited most often, about person with most knowledge is an improper request under Florida law. Like I said, we've tried our best to identify in the interrogatories. We've even said John Lewis, who was the assistant medical director at the time, an employee of Southwest Florida Emergency Management, is the person who has some knowledge that we've been able to identify dating back to 2008, 2009. But to answer interrogatories like this, to somehow create a situation where we're admitting somehow he's a person with most knowledge is just not even the proper standard. There's already been corporate representative depositions, but if there was a corporate representative deposition, we wouldn't have to produce the person with most knowledge. It would just be whoever we designate on behalf of the entity, and that would be at our selection.
Well, perhaps the better way of phrasing this is, who put this together? I mean, so if your objection is that it is incorrectly phrased, I don't have a problem with that. You're right. You get to designate a corporate rep to answer questions about that. But if that corporate rep doesn't know anything, Mr. Knapp, then it's not really that helpful, is it? So, you know, I will allow them to ask, you know, who authored this? And if it was more than one person, or who authored or put this together, then you need to designate that person, and they should be entitled to pose that person.
And we've objected as well. I understand court's rulings on this often, but the plaintiff has far exceeded the number of interrogatories and never sought leave of court. Again, this is going back, even if you look at this one, this is from 2019, I believe, when this was served. There was, by then, even looking at not even trying to break apart interrogatories by subparts, there were 46. When you start getting into subparts, it's significantly more than that. And, you know, there was never any leave of court sought to try to propound.
Okay, well, I'll grant leave of court now. Mr. Weinstein, you know better than that. Based on the arguments and evidence in this case, I'll grant leave of court. But if you want any more, now I'm going to also give you leave to amend your interrogatory to ask who drafted this or put the information together or was responsible for it.
No, I don't have to amend it. I ask it. It's the first two questions. Identify all persons who had any role.
Then I'll strike 6 and 7 and 8. Because you don't need it. You've got a corporate rep and you've got 1, 2, 3, and 4, and 5.
Publishing, well, let's see, hold on. Here's a concern I have with that. Oh, okay. Well, number 2 there, I was about to say that that's just about authorship, not about where you get the substance of the info, but number 2 would.
Yeah.
I do want to point out that. Okay,
let's just move on. So I'm striking 6, 7, and 8, and I'm granting your request. I'm granting leave to ask to request information for more interrogatories. Go ahead.
It's just interesting because I've been trying to depose Mr. Lewis, and I have a motion.
Okay, again, if you want to just spend your time, you've got 3
No, I don't. You're right. Next. You're right. I'm wrong. Next. All right. Paragraph 5. I served a very straightforward second supplemental request for production that simply asked, well, let me say this. We don't have her lawyer here, but I asked for all of the continuing medical education courses that she had for a certain period of time that she said she took at her deposition, because I want to see if she took continuing medical education course on the medicine issue in this case. He said to be, and if we go to its exhibit, let's see, exhibit D, which is on PDF page 47.
Yep.
It's one single sentence. That's the whole thing. And no one objected or responded at all except Team Health, which objected. But Team Health is the one who's going to have this information.
And you're asking for documents setting forth the continuing medical education.
Yeah. Let me, and I, in anticipation of what he's going to say, because he puts this objection and writes about Ameriteam Services LLC. I have testimony under oath by their corporate rep, Team Health. I flew up to Nashville to do this, saying that, well, quote, everything that Team Health did then, Ameriteam does now, because it's the same entity, or it's the same de facto people. What happens is these doctors, these emergency rooms, doctors and PAs, they fly up to Nashville and they give them seminars in CME, or they log on to a portal. I actually have a screenshot of the portal marked as an exhibit at the depot, just so you understand.
You just want the records of continuing education, right?
Yes.
Okay.
I want to see the courses
So
sheet.
what's the problem, Mr. Knapp?
First of all, they're not the same entities. They're two distinct entities. They both have legal purposes. They both have different sets of records and everything else. So to try to conflate this and make a misrepresentation that somehow Team Health LLC is now a Ameriteam or they're the same company ignores corporate form. It's completely inaccurate.
Well, the issue is do you guys have any of these records? If you don't, because you're the wrong entity, then you say, we don't have these records. If you have them, you turn them over.
And we've said
really not complicated.
We said that in this, that it's not the custodian of the records, which would either be held by Ms. Husty as she testified to, or the National Commission on Certification of Physician Assistants, which she testified to, or Maritime Services LLC. Her testimony, which was pointed to as part of the documents, was limited. But on top of that, this is also trying to see what she testified to from graduation in 2007 through October of 2014, and specifically whether any of them concerned any sort of Guada-Aquinas syndrome or any related matter in any way, shape, or form. I mean, these aren't things that we have. We've said that. Mr. Weinstein could certainly subpoena Maritime Services LLC. I understand he tried to get them from Ms. Husty, but we're not agreeing to ignore corporate form.
Well, your response was, Team Health LLC objects to this request as it's vague, overly broad, ambiguous, lacking predicate, and not sufficiently tailored in scope. Even to the extent Team Health LLC could identify CMEs in which Ms. Husty participated in between her graduation in 2007 and October 2014, the request would require Team Health to somehow review all materials concerning all CME courses in order to determine whether any part thereof concern Cauda-Equina syndrome. In addition, hold on. CME materials that are from Team Health Institute, which is not equivalent to Team Health LLC, are proprietary in nature and disclosed without a confidentiality agreement would be improper. Finally, Team Health is not the proper custodian. Well, either you are or you're not. So what's the point of all the other objections, Mr. Knapp?
I'm trying to short circuit issues and trying to work with things. I mean, if a subpoena were issued to a Maritime, I may be the attorney for it. I was trying to get already issues with that resolved. But the answer is I'm allowed to make even.
Well, who has the records?
It depends on which one, and that's because the way that this is phrased is what was referenced on her transcript from pages 13 to 15 of her deposition, which she testified she took some CLEs through, for example, the National Commission on Certification of Physician Assistants. That is not related in any way, shape, or form to the Team Health organization. A Maritime wouldn't have them, Team Health wouldn't have them. It's an entirely separate entity. So when you're asking for something like that, it's something we wouldn't have at all. And certainly, I don't know what, well,
all you have to do is produce what you have. If you don't have them, then you say, we don't have them. That's real simple. I mean, so Mr. Weinstein granted in part and denied in part. If they have them, they turn them over. If they don't have them, then they don't turn them over and you get them someplace else.
Okay. Well, Your Honor, what's the two things? First of all, that's as to Team Health. I presume that it's granted. They never even responded or objected.
Well, with regard to
Jessica Husty.
Jessica Husty, yes, it's granted.
But let me say this. This is kabuki theater.
Well, again,
I could certainly, as he's going to be the lawyer for a Maritime. So
well,
it's making me go through, we're set for trial in February. They're just running out the clock, Judge. There's got to be 27 different entities or Team Health. I filed their ICC filing or their FC filing, SEC. There's 30, it's whack-a-mole, Judge. No, it's not the LLC.
Guess what? This is what happens. The medical community has decided that they're going to divide things up into all sorts of different entities, and you're a plaintiff's attorney and you got to deal with it. So this is what we got.
I mean, what they do is they log on to the portal.
Okay, again, but this is not legal basis for me to do anything. So, all right. So that's my ruling on that.
Okay. Next. All right. Next.
You're technically out of time, Mr. Weinstein, but I happen to have a few extra minutes, so go ahead.
Right. I mean, October 1's the final discovery deadline. All right. So I'll subpoena everything. Okay. Number 6. Are we paragraph 6? Yes. And I appreciate it, Your Honor. Number 6 is the same thing with respect to Dr. Caldwell. I want his continuing medical education stuff, and he's represented by Mr. Gans. And E is 53, PDF 53.
Mm-hmm.
Your Honor, my apologies.
I wouldn't think this would be difficult to get. Why is it difficult to get his continuing education?
May I respond?
Yeah, go ahead.
Thank you, Your Honor. If you look at page 53 and you look at the question, my objection is it's overbroad, vague, and ambiguous. If you look at the question is asking documents setting forth the CME and lectures regarding the scope of practice of a mid-level provider, which he's not, and emergency physicians taken or attended by defendant. I have no idea what he's asking for, Judge, based on the question.
Well, that is a little confusing. Why would you be asking for documents containing medical education courses and lectures regarding the scope of practice of a mid-level practitioner, such as a physician's assistant?
Because as Mr. Gans well knows, and that I allege in the complaint, we have a Florida statute that says that Dr. Caldwell is responsible for all of the negligence of the mid-level provider, the physician assistant, Jessica Husty. In addition, there are rules in effect, we're going to get to that in the next few, that state that it is the requirement of the supervising physician to set forth the quote scope of practice. It's a term of art. It's not something I invented. There is a policy and procedure by the emergency board on ASAP, the college, on setting forth what the scope of practice should be for your physicians. The issue here in this case is that Dr. Caldwell never saw my client in the hospital. We believe he was so injured that he had an obligation to see her, not just a physician assistant. So I want to see what the scope of practice was and whether he took the continuing medical education courses, one of which, by the way, there are articles on this written by the head of Team Health.
Explain this to me. Documents setting forth the continuing medical education courses and lectures regarding the scope of practice of physician's assistants of Dr. Caldwell? You want to know whether Dr. Caldwell is taking continuing education courses regarding the scope of practice of physician's assistants?
I can't narrowly tailor it more. I could have just said, I want all of your continuing medical education courses. I could broaden
so that's a yes. Okay, well, it is a little unclear because it looks to me on first blush that you're asking about the continuing education credits of the physician's assistants, but really what you're asking for is whether or not the doctor, took any continuing education courses regarding the scope of practice of a physician's assistant.
How to use your physician assistants, yes.
Okay, and you're also asking any continuing education credits for emergency medicine physicians from 2010 to 2014.
Sure, yes.
Okay. All right, Mr. Gans, I agree, it was a little confusing, but I think we have it sorted out. So what's the problem with producing that?
Well, Judge, first of all, there's a couple of important pieces of information to determine whether this discovery will tend to lead to anything of admissible evidence, because number one, Dr. Caldwell in his deposition testified and acknowledged he's responsible for the actions of the PA. That's not in dispute. It's no dispute about that. It's Mr. Weinstein asked the questions, Dr. Caldwell admitted it. It's not an issue. Two.
Right, but this is a negligence case, so they're entitled to,
There's more, Judge.
Right.
There's also testimony in this case. There's no requirement by Florida law that Dr. Caldwell be the one to designate what Ms. Husty as a PA can do or not do. And in fact, further deposition, Todd Bethel has testified under oath that was a designation by the medical director of the facility, which Dr. Caldwell is not. So we're searching for something that's not going to lead to any testimony in this case regarding Dr. Caldwell that's any way going to address Dr. Caldwell, the alleged negligence of Dr. Caldwell. Because the alleged negligence of Dr. Caldwell is twofold. One, you're just responsible because it's your PA. And two, and these are the only allegations in the complaint. And two, that somehow because this patient came in at a certain acuity level, you should have known that the patient was sick. There is no allegation against Dr. Caldwell that he was somehow negligent in his hiring or training of this PA. So what relevance at all, what tendency does producing his CME have to do with the issues that are pled in the allegations? Absolutely none. There's only two allegations. You're responsible for a PA. We've agreed to that. In fact, we submitted jury instructions back in 2021 stipulating to it. It's not an issue. And two, the only other issue is you should have known about the severity level. Well, that has nothing to do with what his CME may have been himself personally for his own knowledge of care, because it's also acknowledged he never evaluated or treated the patient. So whether he knows about Claudia Quiner or not, it has no relevance. He never treated her. So it's not a matter of, can I produce? Yes, I can produce his CME if he has any. It's narrowly tailored. It's a matter of, is this discovery leading toward anything that's admissible? And the answer is absolutely not. If Your Honor, if he had submitted a properly tailored request based upon Your Honor's instructions, limited to Dr. Caldwell alone, my objection would be the same, not leading to discovery of admissible evidence. It wouldn't be vague and
I
ambiguous
understand.
anymore.
Well, and he has submitted two requests. One is the CMEs with regard to the scope of practice of the PA, and the other is the doctor's CMEs for a certain time period. So there's two requests in that request. So Mr. Weinstein, I'm looking at the amended complaint with regard to your allegations against the doctor. And it looks like, again, that as Mr. Gans says, how is this information going to be able to be used in court? What are you going to use it for?
Because as to the second allegation, the allegation is that Dr. Caldwell, and my experts have testified this way under oath, that Dr. Caldwell should have seen this patient because a physician assistant who he's supervising, her scope of practice should be not to exclusively handle someone with Claudia Quiner. That's why, number one, I do need his own CME about how serious is Claudia Quiner, and it's why I do need a CME about what type of conditions can you let your physician assistant treat without you seeing them too.
Okay. All right. So I'm going to overrule the objection, but the order needs to reflect that this request is twofold. One is CMEs about the scope of practice of the PA, and the other the CMEs with regard to that specific time period.
Yes, Your Honor.
For the doctor. So there's two requests in there. All right. Moving on.
Okay. Your Honor, the next one, apparently, let's see, the next one.
Your Honor, if I may, Your Honor, this is Rolando Diaz. I want to apologize to the court. I had an emergency this morning with a dog that I had to take to the emergency room, and I completely forgot about this hearing, Your Honor. So I apologize.
Okay, but we're not going to go back and redo the hearing. So, you're welcome to join in, but we're not going to go back and redo the hearings that we've already had. Go ahead.
Understood, Your Honor.
Okay, so number 8, Exhibit G, I think, correct? No, it's the request for admission. I think we actually took care of this in a way at Exhibit F, which is page 62. Very simply, I sent Dr. Caldwell a request for, is this the right one? Yeah. Request for admissions, I guess it's paragraph 7. And he objected to each and every one on the ground that it's beyond the discovery cutoff and it's, I don't know, harassing and abusive. It's simply request for admissions that the actual policies and procedures, if you look at, it's should be 62, that the actual policies and procedures
Admit,
are set
we're looking
forth.
at it at request to admit number one, admit that the emergency department operations in Naples Community Hospital on October 10, 2014, the following sets forth the policy number 2, section 4 of the Naples Community Hospital Department of Procedures. Is that the one we're talking about?
Yeah, yes, Department of Emergency Medicine. And he objected, you see why he objected?
Basically, you're asking, is this your procedure with regard to, on this particular date? Correct?
I'm asking even less than that. I'm saying that, admit that this is the policy and procedure that was in place at that time.
Right, well, it's not particularly clear from your request. All right, and this is directed to the doctor.
Yes, he's the emergency room physician. You see the first sentence, Your Honor, of policy?
Mm-hmm.
Patients will be evaluated and treated by the emergency department physician, with a period. I obviously like that sentence, so I want them to admit that this was the policy and procedure in place. They can argue whatever they want about what that means.
What they've responded is saying, look, this is Naples Community Hospital procedure. So you may have to rephrase it. Hold on just a second.
Your Honor, NCH does not supply a single physician to the emergency department.
Well, you may have to rephrase it to ask, is this the policy and procedure that you were working under at that date and time?
Okay.
But yeah, so that's their objection is it's okay. Yeah, so yeah, that's what I would say, is that you need to rephrase that. Go ahead, Mr. Gantz.
Judge, and again, I apologize, this court having to deal with these, but this is an admission submitted in June of 2018. Mm-hmm. Subsequent to this admission submission, because my objection is Dr. Caldwell is not Naples Community Hospital, nor is this a Dr. Caldwell policy and procedure, it's Naples Community Hospital policy and procedure. But subsequent to this request, because the purpose of request for admission is to see whether it's necessary to litigate certain facts or law. Mr. Weinstein took the deposition of Dr. Bethel, the director, and more importantly, Elizabeth Novakovic, the director of the emergency department for Naples Community Hospital, who specifically addressed this policy and said this is a Naples Community Hospital policy and addressed the provisions, not a physician policy. Number 3, Dr. Caldwell also testified already under oath, under Mr. Weinstein's questioning at length, that he is not aware of any policy and procedures that were attributable to the ER physicians. And therefore, again, this request for
admission— He's not aware of the policies and procedures under which he works, really?
This is not under it, Judge. This is a hospital nursing policy. This is not a physician policy.
Oh, okay.
And that's what Ms. Novakovic testified to.
Okay.
Naples Community Hospital. Mr. Weinstein sued Naples Community Hospital and chose to drop them from the case.
Mm-hmm.
He's gotten testimony. You don't need a request for admission. Excuse me. Mr. Weinstein waited until now to address this 2 years later. Mm-hmm. Okay. But since June 28, 2018, we know absolutely, we have testimony under oath that this is not a issue of law of fact, that this defendant, my client, can stipulate to. It's not his policies. They're Naples policies. And Ms. Novakovic, you can't ignore her testimony. She'll be in the courtroom, and I'll be happy to file it for the judge, Your Honor, to see it. Testified as director of the emergency department. That was her title. This is a nursing policy, a hospital policy, not a physician policy. Dr. Bethel, the medical director of the facility, not Dr. Caldwell. Dr. Caldwell's not the director, testified, this is a hospital nursing policy. So why is this being directed to Dr. Caldwell? The only issue, for Your Honor, is this a proper admission to Dr. Caldwell? And the answer is no. You picked up on it right away, Judge. You said you're asking him about a Naples Community Hospital policy and procedure. Okay.
Okay. Mr. Weinstein.
Yes, Your Honor. First of all, that's not at all what Dr. Bethel testified, but I don't want to follow down the rabbit hole. But Dr. Bethel, I'm sorry, with Elizabeth Novakovic, she actually said that no, this particular policy does apply to the doctors, and they were given to the doctors. Second of all, that's not even, I want to follow down
Well,
the
first of
rabbit
all, let me
trail.
just point out to you guys, this document that's attached to the request for permission or for admission says section 4, physician-patient relations. It doesn't say nurse-patient relations.
Not only that, Your Honor, it's section 4. Section 10 of the policies is entitled nursing policies.
Okay.
Look, I don't doubt that.
Here's the thing. Again, I don't know why you need this request for admission when you've like deposed everybody under the sun already. So I'm not really sure why this really makes any difference and why I'm wasting time on it. But nevertheless, we are here, and it appears to me that you probably need to rephrase your request if you want it answered correctly, which is, what policy or procedures were you operating? Were you working under this policy or procedure? And yeah, I imagine that they could answer that, but your question is confusing. So I'll allow you to rephrase it.
Okay.
If you do that.
Your Honor, I assume that he's going to stipulate to numbers 4 through 7 that he objected to, the truth thereof, to narrow the issue at trial.
All right, this is Mr. Gans.
Yeah.
Mr. Gans.
Well,
4 through 6.
Judge, Judge, I'm not going to. It is undisputed. He's actually submitted a stipulation for the jury that Dr. Caldwell never saw the patient, that he's responsible for any of the actions of the PA by statute, and he didn't evaluate the patient. I don't know how more clear I can
admit it. So say admit. Say admit.
Judge,
Okay, hold on. I can't hear two people
Under
at the same
oath,
time, and I'm assuming that the court reporter can't either. So 4 through 7.
4 through 6. We'll get to 7, but 4 through 6.
Well, Mr. Gans, if you've admitted all this stuff, then why are you filing an objection about harassing and abusive?
because these admissions originally were filed at, Dr. Caldwell already testified to this.
Okay, but Mr. Gans, you guys all knew this, okay? In discovery, you get to ask the question 20 different ways.
But on an
You
admission,
get to ask it in a request to produce. You get to ask it in interrogatories. You ask it in requests for admissions, and you ask it in depositions. So yes, I'm sure that it's been asked before, but this is discovery.
but Judge, a request for admission is different than an interrogatory request for production. A request for admission, you already have under oath, verified by the doctor, admitting these facts. What is the purpose of the
And it
request for
shouldn't be
admission?
a problem for you to admit them again. So your objection's overruled. What's next, Mr. Weinstein?
Number 7 is it's a different policy and procedure. It shows the structure of the organizational chart, including, by the way, team health. And on the right side, if you see, and I just wanted to admit that this is the correct department, that this is the way on October 10th.
Well, again, he's not, the doctor is not NCH. So you can ask him, and you can rephrase this, is this the structure you were employed with? But you're gonna have to rephrase it because he's not NCH.
That's fine. I'll do that.
Okay.
Yep.
What else?
Well, I do the same thing as to number 8, so I'll rephrase that. Number 9, I want an answer to that. I mean, he's been there for all these years. He should know that. He could admit or deny number 9.
Admit that as to emergency department operations at Naples Community Hospital on October 10, the medical director of the department was appointed by Team Health.
Yep.
But how would he know that?
Because he's a team health physician. They all know this stuff.
Well, but he's not Team Health. I don't see that he can really answer this question. So the objections sustain on that one.
All right, number 10, Your Honor. That one?
admit that as to emergency department operations in Naples Community Hospital, between the medical director of the department was on duty was Todd Bethel.
Yeah, Dr. Caldwell was there at the exact same time that night.
Well, is that something that your client would know, Mr. Gans?
I don't know if he would know or not, Judge, but Dr. Bethel's already testified whether he was working or not working. My client didn't recall in his deposition. So all I'm going to do in that situation is refer to Dr. Bethel's testimony. I mean, that's the problem I have with these requests for admissions, Judge.
Yeah.
I understand you can repeat things, but requests for admissions are.
Yes, I understand. Well, I mean, again, I think the correct thing I mean, because again, you're asking him to admit this essentially in an official capacity.
Right.
So what you can ask him for is, do you recall, you recall that the medical director on duty at such and such a time was to Dr. Todd Bethel? Fine.
I'll consider.
He's not responsible for, I would imagine, scheduling as well. I mean, if he recalls, great, but if he doesn't recall, he doesn't recall.
Well, then he could say denied because I don't remember.
Okay.
But there's nothing wrong with the question, Judge. I can't rephrase that any clearer or more narrowly.
Well, to me, that request to admission is directed to whoever does the scheduling. So I'm going to sustain their objection on that one. I mean, again, if you want to rephrase it, but again, I don't really think you need to, but that's what you want to do. Fine. So objection sustained on that one. Let's go to, do we have to address number 11?
No, you don't have to worry about that, Judge. Let's move on.
All right. So what's next?
All right. We're getting there, Judge.
An extra 15 minutes and you're out of that time. So how much more of this do we have?
Well, there are no more multi question ones. It's just 3 and we're done.
Okay.
Okay. And I appreciate your time, Judge. I really do. Request for admissions 9 to both Caldwell and Husty, simply to admit that while she was acting under his supervision and control.
Well, haven't they already admitted that?
Well, to you today, so just admit it. But this one is as to, frankly, this one is as to Jessica Husty, I believe, right? Let me see.
It is to Jessica Husty.
Yeah, the one that H is, let's see. Yeah, that might be a typo that it was to, the one I attached is the one to Husty. I see. I'm looking at the wrong one. No, the one that H. Are there 2 H's? Oh, I see. There are 2 of them apparently. Yeah, one is to Husty, one is to Dr. Caldwell. The one at H, which is number 75, is to Caldwell.
Mm-hmm.
And then a few pages later, in the same exhibit, it's to Husty. He's already admitted it. I want him to respond to a request to admit. He's told you, but see, once I have it, of course, as you've correctly pointed out, Judge, officially, then I could make a motion to have that deemed admitted, and the jury just understands that he's responsible. But he tells you that, but I want a request for admission. He objected.
Well, I thought they filed a stipulation to that effect.
Okay, let him file.
And a jury, I mean, I don't know why we're spending so much time in this. Let's start with Mr. Gans. Go ahead.
Your Honor, again, I don't know how many times I have to say the same thing to Mr. Weinstein. I appreciate what he's trying to, maybe he just forgets about the prior requests or the stipulations. This case has been around a while. I'll give him the benefit of the doubt. But Dr. Caldwell testified in 2017 and admitted these facts. Then we submitted a stipulation contained in proposed jury instruction in 2021, admitting the same thing. I don't know how many more times we can say the same thing, and that's my problem. And in fact,
are we looking at request to admit number 2?
Yeah.
At page number 5 of the PDF.
Number 3. We're only talking about number 3, Judge.
Oh, okay, number 3.
He objected because it called for a legal conclusion.
To admit the defendant, Dylan Caldwell, is liable for any acts or omissions of defendant Jessica Husty acting under the supervision and control of Dylan Caldwell. It is a compound question, but you have admitted to both things, so I'm not sure why there
I know, Judge, I'm not going to waste Your Honor's time with this. I mean, my frustration has been really just, I don't know why I'm getting continued discovery asking me the same thing on a request for admission, which maybe I have different views of request for admissions than Mr. Weinstein and what they're good for.
Okay, well, the objection on this is overruled.
I'll answer it, Judge.
Okay.
All
All right, next.
Almost done. The very last one, in a way, is the most important thing I'll ask you all day, but.
That's what you said before.
So.
We're talking about paragraph 11 of your motion.
We're talking about paragraph 10 of the motion.
Okay.
And I is 83.
Okay.
I need a PDF for that. All right.
This is about a request to produce.
Right. It's a request for produce. It is as narrow as I say in there. I mean, it's razor blade sharp focus, Judge. And it simply asks for all of the materials. These are the two most important ones I'll be in front of you all day, paragraph 10 and 11. It asks for the materials setting forth the scope of practice of the physician's assistant. If you look at number 4 of the request, I quote, "The rules and regulations of the Department of Emergency Medicine," and I actually attach it.
Okay, well, if you attach it, I mean, I realize this is discovery.
And I attached the clinical privileges of Jessica Husty, where it says, for instance, her privileges are to write orders and medical record in compliance with, quote, "protocols developed by the doctor physician assistant team." I want to see the protocols developed by the doctor physician assistant team. They won't give them to me. I mean, I need those.
Well, I have a feeling, I mean, aren't they what's attached? Haven't you already attached them?
No.
Okay. Okay, so this is really a question for both. This is really for Southwest Florida Emergency Management, yes?
Yes, this would be Mr. Diaz. That's what they maintain is the employer of both Husty and Caldwell, and it's a wholly owned subsidiary of Team Health.
Okay. Go ahead, Mr. Diaz.
Your Honor, again, I apologize because I'm literally sitting in the parking lot of this hospital, and I didn't bring the request. I'm not sure which request it is.
Okay, it's plaintiff's request for production as to scope of practice to defendant Southwest Florida Emergency Management Inc. /LLC. And
Your Honor,
go ahead.
So we have produced everything that has been requested of, and I think similar to what Mr. Gantz has been saying, we seem to keep, every time we produce something, he wants it, he asks for it again, we provide it, we ask for it again. These are all been taken care of at the time of the deposition of Dr. Bethel. It keeps asking the same questions over and over again. The scope of practice, if he's asking specifically as to the mid-level that existed at the time, I believe
let's go over it. So number 1 is all documents, materials setting forth the scope of practice of physician's assistants, including Jessica Husty, assigned to the Naples Community Hospital Emergency Department that were in effect on October 10, 2014.
And so just to let you know, Your Honor, the scope of practice, this is not a building owned by Southwest Florida Emergency Services. It's a building owned by the hospital.
Right,
it is a building operated.
But you employ the physicians and you employ the physician's assistant. And as an employer, you should have something written down about what they're supposed to be doing.
Your Honor, their scope of practice is based upon the privileges that are extended to them by the hospital. So they're licensed individuals. Their scope of practice is actually controlled by the hospital because the hospital is one that decides what they're allowed to do as anyone in the hospital, any physician. They don't just come in there and decide, oh, some employer decided what I do. It's actually the hospital that says this is what you're allowed to do in this building. So the scope of practice are the privileges, which is what we've already more than once said. Please refer to the privileges as per the hospital's documentation.
Okay, so you have no documents that pertain to the scope of practice of your employees.
To my knowledge, Your Honor, what we have is the privileges. So if they want us to produce the privileges that the hospital extended to Ms. Husty, then I'm happy to do that. But it's based upon
I
the
understand.
privileges.
Again, this is a request to produce sent to you guys. You need to produce what's in your possession or control. If all you have is a copy of the privileges extended, then produce that.
And I'm not saying we do, because that's why I refer him, since this is a document in the possession and control of the hospital, which is the one that extends privileges.
But if you don't have it, then you say we don't have it. It's not in our possession and control.
I will then do that way, Your Honor.
Okay, so you need to respond to 1, 2, which is all documents setting forth scope of practice of Jessica Husty. I'm not sure why that's different from number 1, but okay.
Well, unfortunately, that's the problem, is that after 4 or 5 years of discovery, we just have the same rehashing. But I understand your ruling, Your Honor.
Rules and regulations of the department at Naples. Okay, number 3 says the rules and regulations of the Department of Emergency Medicine at Naples Community Hospital. Why would they have a copy? Would you have a copy of that?
Yeah, because of number 4, Judge. I did it broad and I did it targeted narrowly.
Okay. The rules and regulations of the Department of Emergency Medicine referred to in Exhibit A, which is the policy of the medical director.
Right. They employ, you've heard Mr. Gans admit, they employ Todd Bethold, who is the medical director. You've heard him say that he was the medical director. And that policy and procedure, I just quoted straight from that.
Well, right, but what it says is in that policy and procedure is the credentials and qualifications of the medical director are established under medical staff bylaws and the rules and regulations of the Department of Emergency Medicine.
Right. They run the operating room. They don't know what the rules and regulations of the Department of Emergency Medicine are. That it's their own stuff.
Right, but do they have copies of it? I don't know whether they maintain copies of it or not. Why would they maintain copies of it?
Of the rules and regulations of the emergency department that they're running? Let them say that we don't have them. We'll have fun with that at trial.
But that belongs to...
Okay, Mr. Diaz, what?
Your Honor, that belongs to NCH, and this is kind of the problem. You see, Mr. Weinstein has created this thing in his head that because there's a person called medical director, that somehow he must be the guy in charge of the entire building and owns the building. NCH, it's their emergency room. There are different medical directors in every different department. Those are individuals that are serving at the capacity of the hospital.
Let's be clear about who created this problem. It's the medical industry that has created this problem of dividing everything up into separate entities. So that's the problem that we have. And that's what gives us a very frustrated Mr. Weinstein. But the issue for the court is, do you have possession or control of any of these documents? If you do, you got to turn them over, even if they weren't originally your documents. If you just maintain them in your files for whatever reason, then you got to turn them over. If you don't, you say you don't have them.
Yeah, I think the difficulty is possession and control. Control is by the entity that owns those documents. NCH is the one that owns. And Your Honor, you understand
that
the hospital
has... I understand that they have control over those documents, but if you have possession of a copy of them, you turn it over. Otherwise, you don't have to.
That's fine. And that's if it's a matter of do I have a copy of it, I'm happy to find out if I have a copy of it. But when he's asked me to produce something that is actually owned by the NCH, of which it's essentially trying to, when you do these things, is asking the entity that has possession and control, because I think that's the important word here, control as the records custodian of that document.
Okay, but
that's
Mr.
not
Diaz,
me.
you are responsible for producing whatever you have in your possession or control, not and control, or control. All right. And I think the point Mr. Weinstein is making, which may or may not be valid, I don't know, but the point is that you're the employer of these two individuals. As an employer, I mean, employers, post things all the time on the wall, various laws, various regulations, various this and that. What documents do you maintain as an employer of these two individuals So, produce what you have in your possession or control. So if you have
Understood,
a copy,
Judge.
produce it. If you don't have a copy and you don't have control, okay, just say so.
I will do so, Your Honor.
Okay, and I think that applies to everything on this request to produce.
No. Well, I want to discuss 5 and 6, Your Honor. I just want to make sure, because those have nothing to do with the hospital. They're taken directly from the clinical privileges of Jessica Husty.
Mm-hmm.
Okay, number
but
5.
The clinical privileges are extended by the hospital.
And by the way, that was one of the things he asked for.
She signed it.
Your Honor, and this is the interesting thing.
Mr. Weinstein, stop. Go ahead.
We just dealt with him saying, I don't know what her scope of practice is, and he's just admitted to us that he has her clinical privileges signed by her. This is why again, Your Honor, I understand you're dealing with all our frustration of many years dealing with the same issue, but he already has a document, but then he just changes the name of the document.
What he wants is he wants to see whether you have the document. So if you have the document, again, I'm not going to change my ruling.
And you can't conflate clinical
Understood,
privileges with scope of practice. Clinical privileges say you can do this here.
Again, Mr. Weinstein, I don't think I need to. I mean, I have already ruled if this particular defendant has possession of these documents or control over these documents, they have to produce them. If you do not, Mr. Diaz, then you say we don't have possession and we don't have control.
That applies, Your Honor, to the physician assistant supervision data form under, okay? And it applies for the record.
Yeah.
To the, quote, protocols developed by the doctor physician assistant team.
Again, regular rules of procedure and discovery apply. If they have possession of it, they produce it. Or if they don't have possession of it, but they have control over it and can get it, then they produce it. If they don't have either, then they say they don't have either.
Well, number 7 requires her to keep a copy. So I assume
again, if they don't keep a copy, then they don't. Again, we're talking about discovery here. You can make your case in court, Mr. Weinstein.
Okay.
All right.
So,
are we done?
No, the most important one. I saved the best for last. Number 11.
Mm-hmm.
Be on PDF. I didn't miss one, right? PDF number 106, Your Honor.
Mm-hmm.
Let me get to it. And that's a very recently filed and, I'm sorry? Oh, okay. I know there's not a tab for it in my copy. So is this it? I don't see J. I know it says J. I want to make that to the very beginning. I apologize for 1 second.
Okay. Yeah, J is 105.
Okay. Yes. 105, 106. Got it. Okay. Your Honor, we know that in 1973, the rule was changed that asking for them to admit a legal fact is permissible. And there's a case, Florida Supreme Court case called Salazar, and I have the slide if you need it on point. They have asserted a defense under 768.132B2A that basically they're immune from this lawsuit. That because this person who they discharged home was unstable. Put aside that Dr. Caldwell and Jessica Husty have said, no, he was stable when I discharged him home, and the whole time. Put aside the fact that the condition in the medical record says stable. Those requests for those jury instructions that Mr. Gans referred to you before, his side, he asked that you charge the jury in there that their burden of proof is clear and convincing evidence that Jessica Husty, that Dr. Caldwell or Jessica Husty knew that they were causing harm. It's essentially immunity. That's what they asked for under this statute. The record belies that. I mean, they discharged them home. So I'm asking them to admit that under the statute, the person was stabilized, because the statute says If the person was stabilized, the immunity doesn't apply.
68.132 is part of the Good Samaritan Act.
Right, exactly.
Where
And it defines, the word stabilize is right from the statute. I don't know what denied as phrased means.
Okay. Okay, well, just FYI, this is not a 30-minute hearing, Mr. Weinstein.
I know, Your Honor.
So don't do this again.
I will not. And in fact, I've requested an hour and a half for the punitive damages motion. And
punitive damages are not that hard because all of the evidence is in the record, and I do review my motions and such beforehand. So I don't think that that's all that difficult. It's just time consuming for me, most of which I do before the hearing. So
sure,
you're welcome to schedule it that way. But FYI, I don't know that I see a punitive damages issue here based on everything you've told me, but I haven't looked at all the evidence that you probably are going to file with regard to that.
I have. No, we haven't talked about any of those issues, Judge.
Okay, so this is a medical negligence case, and you guys are set in February. Have you arbitrated this case yet?
Yes, Your Honor.
Okay.
Yeah, they filed a trial.
And have you mediated this case?
You've ordered us back to mediation because it's been years.
Yeah. So, but you haven't done that yet.
Correct.
Okay.
The order requires it by December.
Okay. All right. So let's deal with this last part. Go ahead. Anything else you want to tell me about this, Mr. Weinstein?
I quote the statute. Quote, capable of receiving medical treatment as a non-emergency patient, unquote. They discharged him home. Admit it. I don't know what denied as phrased means. And these are, for the record, requests to Southwest Florida, requests to Jessica Husty, a request to all defendants, and I've attached them all.
All right, so let's start with Mr. Diaz first.
Your Honor, here's the dilemma.
Mm-hmm.
Mr. Weinstein is trying to do everything he can to essentially pre-try this case, because one of the issues in this case, which the jury's going to have to hear and have to make a determination, is whether they believe Mr. Weinstein when he says that Mr. Alfaro was unstable because he had a cauda equina that was essentially a ticking time bomb in his spine. Mm-hmm. And that this patient could not be discharged because this patient was in an emergency situation and needed to have additional care. Mm-hmm. If the jury believes that, Your Honor, if the jury for whatever reason believes what he is saying and says, well, we do believe that he was in an emergency situation and was unstable, then this statute has to apply. Then we have to look at the statute, because by virtue of his argument, this statute then comes into play. If the jury believes that he wasn't.
Okay, I'm looking at the statute. So explain to me how this statute comes into play in this particular situation based on your understanding of the case.
If the patient is in an emergency situation and unstable, then the standard of care is no longer just what a reasonable physician would do. It's a higher standard.
Okay.
That's why this law exists, because since you don't have the luxury of time and you don't have the luxury of a patient with a cold or simple things, they have raised the standard, saying, no, there's a higher standard you have to now basically accomplish. You have to be able to prove your case to a higher standard when you're dealing with a patient is unstable and an emergency situation. That is what he's claiming. In one breath, he's saying Mr. Alfaro was unstable in an emergency situation, cauda equina. This literally a time is clicking down on his spine, and he should never have been discharged. Mm-hmm. If the jury believes that, then it's a higher burden of proof by virtue of the statute. If the jury believes that he wasn't in an emergency situation, there wasn't any indication of cauda equina, well, then the jury's either going to say we don't think it was negligence, but the bottom line is that then it isn't going to be this higher burden of proof. He can't sit there now and try to take away what the legislature has provided, saying, well, if you want to make this argument in the emergency room and claim that your patient was in such an emergent situation, it's a higher standard of care or a higher burden of proof.
Okay,
and so this is a question that has to go to the jury.
But Mr. Diaz, isn't this what these questions go towards? It says, at the time Jessica, for example, at the time Jessica Husty first examined Mr. Martinez at NCH on October 10, he was, quote, stabilized as defined by section 768.132B2A. So, I mean, you guys discharged him, so I'm assuming that you thought he was stable. So I guess I'm curious as to why this is a problem.
Your Honor,
I think, Your Honor, I think it's important, before you, Mr. Gans, I'm sorry. Your Honor, I think the important thing is actually maybe Mr. Weinstein should be answering this question, because if he's going to sit there and say, oh, well, I don't believe the statute applies because I'm going to stipulate the patient was stable and was not in an emergency situation, well, then that's something, because he has the burden of proof. I don't have the burden of proof.
Right,
it's his burden of proof.
We're here about discovery. You are welcome to send a request for admissions to Mr. Weinstein. I don't have a problem with that, but we are here on these, and I guess I just don't see what the problem would be in answering this question. I mean, stabilized is defined by the statute. I mean, clearly there's the statute talks about stabilization. So what's the problem?
May I respond, Your Honor?
Well, let me hear from
because
Mr.
I think
Gans first, and then I'll go to Mr. Gans.
Your Honor, again, what he's asking us to do is he essentially wants us to say, yes, this patient was stable, and therefore the statute doesn't apply. But our position is it depends on what the jury determines. If the jury feels that this patient was not stable because they believe his case and should have been kept there and should have additional studies, then the statute does apply.
But the issue is what your client believes.
Your Honor?
Go ahead, Mr. Gans.
And I apologize, I don't want to step in, but this is something that I deal with a lot.
I think it applies to your client too, so go ahead.
Yeah, and it is something that I deal with a lot, and it's something close to things I've lectured on and dealt with in front of many courts. So let me go over this for a second. The problem, we're starting with the request for admission. And the problem with Mr. Weinstein's request for admission and why it's denied as phrased is because 768.13 does not define what stabilized means. And his request.
Oh, I think it's 1.3. Yeah, go ahead. Yeah.
768.13 says you have to comply with certain requirements pursuant to federal and state law, 42 USC 1395 DD, and the Florida Access to Care Law, which is chapter 395. If you're complying with those requirements, emergency department provider, you're entitled to this protection until what Mr. Weinstein's referring to is where the statute says the patient is stabilized and capable of receiving treatment as a non-emergency patient.
Right.
But in order to
and
go
that's pursuant to 768.132A. Yeah.
Right. Now, the problem is that the definition of stabilized is not found in 768. It's found in two locations, chapter 395.002 and
say that again, 395.
CFR 49.24. So in other words, because the law says you have to go to the access to care law and the anti-dumping law, you have to go to their definition. And stabilized means something which is no material deterioration will occur within a reasonable medical probability to result from occurring during the transfer or the patient leaving the facility. So the problem with the request for admissions, let's start first there, is that the requests for admissions are asking to admit a definition that doesn't exist in 768.13.
Okay, but that's just semantics because
it's not.
Because 768.132B2A is stabilization is defined, as you said, by 395.
Correct.
So I don't see. I mean, it's like saying, you know, if let's say, for example, there was a definition in 768 someplace, you could still just say 768 and it's still, I mean, I just don't see why that makes a difference.
It's a huge distinction, Judge, because the definition of stability and the statute, your Honor asked a very important question, which was, well, aren't you going to agree that you discharged the patient was stable? But the statute, and this is something we can go into at a later date, protects providers because of the nuance of their job and not being able to make that determination till the very end. And what Mr. Weinstein is accusing them of, and what his experts are accusing of are making bad decisions during the course of that required evaluation. So that's why it's a protected, and we can go into this another date, but since we're talking about requests for admissions, it's important. The reason why they're denied as phrased is because Mr. Weinstein is not citing to the correct definition. And
Okay.
because that definition
So if he was citing to the correct definition,
Yes.
which would be including chapter 395 and CFR 4924, if he were citing to those, you could answer the question.
Yes, Your Honor.
Okay. Mr. Diaz, do you agree?
Yes, Your Honor.
All right. So Mr. Weinstein, what's the problem with that?
Because number one, that's not the definition of stabilized at all. That's what defendants always try to do in this. They try to find a narrow.
Okay, well then what we have,
elsewhere.
then what we have before I can rule on this is I need to rule in a motion in limine or a motion for summary judgment.
Well, yeah, well, that's the whole point. Your Honor, a few things. Number one, yes, I'm going to move for summary judgment on this. That's the purpose of the request for admissions. It's always the purpose of request for admissions. Number two, never in the history of Florida has this statute, best I can tell, let them find a case, been applied against a plaintiff in a case where he was discharged from the emergency room. This, you'd make new law, Judge. Number three.
Oh, boy, it's just what I want to do.
I know. Number three, I want to, my experts have testified under oath that he was stable under the statute. I will stipulate he was stable as defined by the statute. But you were right, Your Honor, that this is about their position. I'm going to move for summary judgment on this. They know I'm going to move for summary judgment on this. Their own doctors have, I said, was he stable at the time? Yes. Husty testified that. Caldwell testified that.
Okay, well, because we're dealing with requests for admissions, which have a more specific and have a different legal position, I'm going to deny the motion with regard to that. If you want to rephrase it to include the defining statutes, great. If not, you guys file a motion in limine.
Your Honor, it is a defining
Mr.
statute.
Weinstein, this is my ruling. You can file a motion in limine for the court to rule on this issue of law. I'd be happy to do that, and I'll reconsider your motion to compel at that time. But at this point in time, I'm going to sustain their objection.
Your Honor, I have a request for the court to look at number 7 and ask whether your ruling applies to number 7. Paragraph 7.
Yep, I'm looking. Hold on. Yes, it implies to anything that you have referred to in 768-132B2.
All I'm asking is, was he, quote, capable of receiving medical treatment as a non-emergency
And it's the
patient?
same phraseology as stability. It's not defined in 768. So if you want me to define it, somebody file a motion to that effect, and I'll do my best to do that. And I can reconsider your motion to compel, perhaps at that time. But at this point in time, I'm going to sustain their objection.
Because, all right, as I understand it, because stabilized isn't defined in the statute?
As stabilized, and also the phrase capable of receiving medical treatment as non-emergency patient. It's not defined. There's a disagreement as to what the definitions are. Want me to rule on that? Fine, but I can't rule on it in the context of a motion to compel.
Okay, I mean, I'm going to be moving for summary judgment on it, so.
Great.
Okay. One of these instances where the new standard is going to help, right? Okay. That is what I have, Your Honor.
Okay.
Except administrative thing. Your JA had sent for the motion for punitive damages. Your JA gave us 4 dates in July. Mr. Diaz had filed notices of unavailability. So we had asked for further dates, and that was about a week and a half ago, and we've received nothing from the court yet.
Well, you're not going to get them from me, so you'll have to email my JA again. I mean, the dates are going to be in August. Is that what you want? I mean, if July is it's going to be our first for motions for summary judgment, given the time requirements that are now under the new rule. you're not going to be able to deal with a motion for summary judgment occurring in June. So,
Right, but this is a motion for punitive damages.
oh, punitive damages. Oh, well, do you have all your stuff already filed on that motion?
Yes.
Oh.
Yep.
Well, I'm just going to tell you, it's a very dangerous thing for me to schedule my own hearings because I usually mess it up. And I can't, well, our website's even down, so that's even.
Judge, we asked your JA and for August, and it wasn't that I just filed a note. My notices of unavailability have been in play for several months. And so we said August would be when we're all available for this hearing. Mr. Weinstein, for some reason, thinks that I don't have to be at that hearing, that it can be at an associate. Obviously, it's a hearing that I was at the first time and I want to be and need to be at the second time. So we asked for August. I think she's working on dates. I'm not sure why Mr. Weinstein thinks
here's the problem that you guys have, which is, the courthouse is opening up on June 21st.
Yes.
I have a tsunami of trials backed up. So I'm going to be trying cases from now until the end of time. I think, at least for the next 6 months. So August is going to be busy. I don't know how much you want, an hour and a half. I don't know if I can give you an hour and a half in August. So I can give you an hour and a half in June. I can give you an hour and a half maybe in July because I only have 4 cases set for trial in July. But August we're going to be busy. So that's my longer hearing time is generally. One day I would say that I might be able to do something would be, see what that is. I might have time in the afternoon of Monday, August 2nd.
I'm available.
Okay. How is everybody else? I'm not sure you need an hour and a half, but just because you have parties.
It was interesting. I actually asked for an hour 15 and your JA's email said that you wanted an hour and a half, actually. That's how that happened. I'm fine with an hour 15.
An hour and a half is fine because we have more than one defendant, so.
Right.
That's fine, Your Honor.
Okay, how about Mr. Gantz?
It doesn't, the motion's not against my client, Judge, so I'll make sure someone's available.
Okay, so Monday, August 2nd, motion for summary judgment.
No, it's a punitive damages, Judge.
Oh, that's right, I'm sorry.
I'm going to apologize for the length of my motion ahead of time. I had a lot to say.
Oh, surprise. Let's see, punitive damages.
Your Honor, what time that afternoon are you?
I don't know. That I'm going to leave up to
Okay.
my judicial assistant.
I will have my office lock up the entire afternoon.
I'm just sending her an email now. She should get back to you about that. If you don't hear from her, she's got some medical things going on this week, but if you don't hear from her, email, tomorrow and say, we're just waiting on a time for that August 2nd motion for punitive damages. So, and on Mondays, I think in the afternoons, I do in-person proceedings. So unless you specifically want it not in person, let me know. The problem is with our technology, I can't do a combo. I can't do a combination of Zoom and in person. I can only do Zoom or in person. So I'm happy to do it either way, doesn't matter. But having you guys in person does not influence the court either way. So especially in a case where really my only challenge is, as Mr. Weinstein found out, is just what page something is on. As long as I can access that, I'm fine. So, all right, anything, Mr. Weinstein, you need to do the order after you've circulated it, forward it to my office email address in Word format, please.
Sure.
All right, Mr.
I can't
Diaz,
tell you
I understand
how appreciative I am, Judge, for the time you've given us. I know I speak for them as well.
Mr. Diaz, you're going to have to get with Mr. Weinstein about my rulings on things that may or may not affect your clients.
Yes, Your Honor.
If you have a legitimate basis for filing a motion for a hearing, of course you should do that. I'm not telling you not to. But
No, I understand, Your Honor. Again, my apologies. I just,
I'm not personally assaulted.